Hi, Wes Scott from Lifeback Law Firm. Today we're going to talk about should I sign, I'll spit it out, a reaffirmation agreement in my Minneapolis Chapter 7 bankruptcy, and it's a good question. You know, it's a good blog. First of all, what is a reaffirmation agreement? Well, a reaffirmation agreement is an agreement where you give the creditor, the lender, your liability back to the creditor in Chapter 7 bankruptcy. There's no such thing as a Chapter 7, a reaffirmation agreement in a Chapter 13 bankruptcy. We're only talking about Chapter 7 bankruptcy. So you file a bankruptcy. The example is you have a car loan. The loan is $10,000. The vehicle's worth $5,000. The lender wants you to sign a reaffirmation agreement, giving your liability back to the bank so that you're liable on a $10,000 loan, but where the vehicle's worth $5,000. Do you think you should sign that? I mean, almost always we suggest consider not signing these things. Giving your liability back should be very, very it should be thought about deeply before you do it. Because the whole point of filing a Chapter 7 bankruptcy is to get rid of your liability, right? And now you're giving it back. Well, you sign the reaffirmation agreement, okay? 2 months later, the car blows up. Now you're liable on a $10,000 loan and the car is worth scrap, $500. You going to be happy about that? I don't think you will be. And so I think it's borderline malpractice for a lawyer to suggest you sign a reaffirmation agreement in a Chapter 7 bankruptcy. I really do. I mean, I think it's borderline malpractice. Now, there are some banks that take the position, if you don't sign this reaffirmation agreement, we're going to repossess your vehicle. Typically a credit union, I mean, I think consider not banking at a credit union. In fact, recently I had it happen where the client filed a Chapter 7 bankruptcy, was current on the loan. Her mom was a co-signer on the loan, and they repossessed the vehicle. But that was an unusual set of facts because in that situation, I think the underlying facts gave rise to a claim for wrongful repossession, which I intended to sue out. But the lender capitulated and undid the repossession. So I think the general advice is don't sign a reaffirmation agreement. If you want to keep the vehicle, if you want to keep your house, you keep making payments on it. And go about your business when the time is right. When you are ready to get your life back, reach out to Lifeback Law Firm, Minnesota's most kind and helpful bankruptcy law firm. You're going to be so thankful you did.